Welcome back, everyone. We will now begin the next session, the lecture on international economic law and the rule of law. We would like to once again invite President Locknie to introduce our lecturer.
So welcome back, everyone. We've had a very interesting morning so far already, and our next item in the program is the keynote lecture on international economic law and the rule of law, something that's very apt, given what we've heard so far in the opening remarks of the morning. I'm very pleased to introduce the keynote lecture speaker that we've invited, Professor Gregory Shaffer. I assume he's online already. Okay, he'll be coming on to join us momentarily. Unfortunately, Professor Shaffer is not available to join us in person. Greg is a Scott K. Ginsberg Professor of International Law at Georgetown University Law Center. He's the immediate past president of the American Society of International Law, author of 12 books, including an award-winning book, Emerging Powers and the World Trade System, The Past and Future of International Economic Law. And his newest book is The Rule of Law Under Pressure, a Transnational Challenge. So welcome, Greg. Can you hear us well from where you are?
I can hear you fine. Can you hear
Wonderful.
me?
We can see and hear you well. So I've just given the brief introduction. I'm not sure if you heard that, but I'll hand the floor over to you, and we await your remarks. Please, Greg.
Great. Thank you so much. I'm timing myself just so we can all be on time. Yeah, thank you. I appreciate the invitation and the organizers' confidence in me to give these remarks. It actually means a lot. I was present in 2006 when we met in Bretton Woods, and Colin Picker and others, we talked about the creation of the Society of International Economic Law. And that's its birthplace. And it was really through Colin as his brainchild. And we're all thankful for that. And now here we are, 19 years later, in a very different time. Sorry I can't be there. I've had a lot of travel and just a lot of international travel, so I couldn't make this trip. But I'm very appreciative that I'm still able to give these remarks. I'm just sorry that I won't be able to discuss them with you at the conference and discuss your work, your valuable work. But the remarks I'm just going to speak to you as without being able to see you, unfortunately, because I'm just looking at myself on the screen. But it'd be nice to be able to see the audience instead. But I've used the opportunity to write to start drafting an article on this important topic. And so if anybody's interested in seeing the draft, just send me an email. I'd be glad to share it with you. I mean, international economic law obviously is at a critical juncture today. These are revolutionary times. They start with the rise of the second Trump administration, which is attempting to undo international economic law. And in response, even many critics of the trade regime have felt at least partially pressed to come to its defense, as the power-based alternatives to multilateralism orchestrated by the current administration is much worse than what now exists. In this talk, I'll think about how should we think about the rule of law as applied to international economic law. And it's a tricky matter, given the history of international economic law and the critique of international economic law for various biases. But it's important for us to do so. And to my knowledge, there's no real systematic work examining international economic law from a rule of law perspective outside of investment law, where there's a great deal of work and a great deal of debate, although rule of law slogans are often tossed about. I build here from a book that came out by me in January, some BCX Boubet and others have chapters in it. It's called The Rule of Law Under Pressure, a Transnational Challenge. And what really struck me was both a sort of compelled me to work and put together this book was both a normative and analytic concern. The normative was what happened in the United States in 2000 in the attempt to block the peaceful transfer of power. But analytically, you see sort of challenges to the rule of law around the world. So I wanted to assess these in terms of why are we seeing all this at once? It's not just by chance. And in doing so, I wanted to look at the interaction between what's happening in international law with what's happening to in the domestic sphere. And that what brings me then to sort of think of how would we think about this in terms of international economic law. And so my talk's going to be in 6 parts. Part 1 is just going to be set forth how we should think about what we mean by the rule of law. Part 2 is going to be assessing what are the different sources of arbitrariness which are pose challenges to the rule of law. Part 3 is going to apply these to international economic law itself. Part 4 is going to be thinking of how do we think about international economic law from what I call a transnational perspective. Part 5 will address the limits and challenges with respect to international economic law and its rule of law challenges itself. And in Part 6, I'll talk about what might be done. I'll try to all do that in a relatively rapid way. So first, just in terms of the rule of law, different actors put forth many different conceptions of the rule of law. The World Bank sort of is focused more on removing barriers to trade and freeing up, ensuring contracts are enforced and property rights are enforced. The UN Secretary General, Kofi Annan, put forth famous statements which incorporated human rights into the definition. UN Security Council has conceptions which focus more on security, peace and security, and law and order. UN General Assembly has also put forth a declaration. And outside of that, of course, there are many different philosophers with competing conceptions that range from thin procedural conceptions of the rule of law to thicker, more substantive human rights-oriented conceptions of the rule of law. And based on this, you have many international institutions that have gotten involved, and often they create checklists based on these different conceptions. And then the question is, do different countries meet these checklists? And and because of this, you get this sense that the rule of law is, in the words of the legal philosopher Jeremy Waldron, an essentially contested concept. And I think that's what you see this repeated in the literature, and I disagree. In terms of the rule of law, I think it's dangerous to think that it's sort of something up for grabs with different conceptions, because then it just becomes a tool in the arsenal of lawfare in the United States, for example, you see both President Trump and President Biden speaking of the rule of law, but using it in order to attack their opponents. You see, in China, Chairman President Xi Jinping coming up with a different conception of the rule of law with Chinese characteristics, in which the Chinese Central Communist Party is at the center. And I have a different starting point. My starting point is that actually the rule of law has a very clear goal, and that is to constrain the arbitrary exercise of power. And that, in a sense, one can view then as a universal good. But that's with respect to the goal. With respect to the means to attain this goal, we just simply don't know what works. And so there are many different means. It's not just then a European conception or American or a Northern Anglo-Saxon conception going around the world with checklists which saying, oh, our institutions, that represents what the rule of law is. Rather, one has to be look at different local traditions, different historical traditions, different local contexts in terms of what works, what doesn't work in these contexts with respect to defending, constraining the arbitrary exercise of power. And this is I come out of, I'm a legal realist, was very influenced by the pragmatist philosopher John Dewey. And because Dewey really wanted us to focus on goals and then practices. And the practices we assess in terms of how they meet these goals or advance these goals. And some work, some don't work in different contexts. And we learn from experience. So the point of the rule of law is to temper the arbitrary exercise of power so that the exercise of power, the aim is to set boundaries in and channel powers exercise through known legal rules, so and institutions that apply equally to all. What matters, though, ultimately is the institutionalization of these norms so they count as a source of constraint, so they count as a resource that we can use so that they become ultimately a culture of practice. So note, I don't define the rule of law in terms of legal compliance or in terms of legality. And I don't do that because law can be for good or for bad. Take the law of Nazi Germany, take the law of the Jim Crow South, take the law of apartheid South Africa, take the law of the Berlin Conference of 1885. And the idea that somehow this compliance with immoral law, that doesn't constitute the rule of law. And that's the reason why it's so important to distinguish a conception of the rule of law as an ideal from rule by law. Okay. But then once we say that the rule of law is about constraining the arbitrary exercise of power, when this faces another abstract conception, what's arbitrariness. And there's a smaller philosophical literature on arbitrariness, but basically it's about the constraining that when power is exercised, those who exercise it, it should be controlled so as to take into account the interests of those who power is exercised over. But once again, this definition is abstract, and so I think it's much more fruitful for us to turn to a problem-centric approach where we address what are the sources of arbitrariness, and then how can the rule of law address those sources of arbitrariness. And so I put forth 5 primary sources of arbitrariness. If others come up with more, let me know, but I think these are central examples. And the first primordial one is when law doesn't apply to those in power. If you think, just in terms of my own country, the United States, the U.S. Supreme Court, when it held that the President of the United States is subject to absolute or presumptive immunity, this is highly problematic, especially when you combine it with the pardon power, so that if the president is immune and the president can power whoever he gives illegal instructions to, simply the law no longer applies to those in power. If you think about a second source of arbitrariness, which is put forth by Joseph Raz, Lon Fuller, and many others, you see this is in terms of that the law should be prospective. It should be consistently applied. It should be transparent, it should be published. It should be relatively stable. It should be non-discriminatory. There's these attributes of the rule of law. What the aim is to create a certain certainty and predictability so we can plan our lives, so that we know how power can be exercised against us. And if you think about, one of the sort of autocratic tropes that comes from Latin America, but applies anywhere, which is the saying that, to my friends, everything, to my enemies, the law, apply the law to the enemies only. A third source of arbitrariness is, and this is Joseph Raz really highlights, says the importance of an institutional machinery, a place where you can be heard, where you can challenge the exercise of power over you. A fourth source of arbitrariness is where power doesn't have to give reasons to when it applies the law. Reason giving is central to the rule of law. Now I turn to the Nazi theorist Carl Schmitt, and his famous saying that, in terms of the sovereign power, it's he who decides the exception. Well, the mother of all exceptions is national security. So if everything becomes national security, and national security is not viewed as something which is judiciable and consequently subject to independent review, then there's no longer any reason giving except a leader, a power holder, just stating the magic words, national security. And then the fifth is proportionality, the proportionality between a violation and a sanction. If you think what happened to Navalny in Russia, a combination of multiple, finding of multiple violations and then put up forever in Siberia, basically to die. And so I wanted to give those sort of general uh, visions of what are the sources of arbitrariness and now try to apply them to IEL, International Economic Law. So first of all, if you think about the first primordial concern with respect to the rule of law is when the powerful are not subject to the rule of law. Well, now we're the most powerful country in the world, the United States, basically declaring that treaty commitments, are not binding on it. It can sign a treaty with Japan, sign a treaty with South Korea, sign one with Canada and Mexico, and then suddenly say, "Oh no, we're no those what we agreed to is no longer binding on us, and we're going to raise tariffs against you." And they could do this with respect to the whole world. And it does this not only internationally, but also domestically, so that domestically taking the position that the president's raising of tariffs on national security grounds are not subject to judicial review. And what happening is then the undoing of the entire international economic trade order, the ending of most favored nation treatment with respect to countries, the idea that the concept of a binding tariff is simply out the window, the functioning of a dispute settlement system is blocked, and so there's no review. And so a small country like Lesotho is threatened with being subject to 50% U.S. quote reciprocal tariffs. Sri Lanka, with a quarter of its population living in poverty, subject to quote 44% reciprocal tariffs. Switzerland, which opposes no tariffs with all other than on agricultural products, subject to quote a reciprocal tariff of 31%, and so forth. So, there's a long history to quote American exceptionalism and declarations of it, but this is no ways has it been used before to completely destroy the post-war World War II institutions that the U.S. was so central to creating. The second source of arbitrariness is where the application of law is such that one cannot plan one's life. Well, if you think about this in terms of international economic law, across the board, so much of it is about creating certainty and predictability. Article 1 of the IMF articles includes among the IMF's purposes to promote exchange stability and maintain orderly exchange arrangements among members. If you think about the WTO dispute settlement system, Article 3.2 of the dispute settlement understanding provides that the dispute settlement system is a central element in providing security and predictability to the multilateral trading system. Security and predictability are central to jurisprudence in trade and investment law. If you think about the Section 301 case early on, brought by the European Union against the United States, which we'll discuss further below, the case the panel stressed the importance of security and predictability, which affects mostly individual economic operators, not so much states, but the everyday traders. The third source of arbitrariness is where there's no institutional machinery, where one can contest the application of law against one. And here we think about the neutering of the WTO dispute settlement system, undermining the ability of affected stakeholders to work with their states to challenge measures which are being used against them. A fourth source of arbitrariness is where no reason is given. If you think about the WTO, one of the fascinating aspects of the sanitary and phytosanitary agreements was really, in my view, its focus on reason giving, about transparency, about creating a committee system in which you had to respond to challenges and say why the SPS measure was necessary, about giving some sort of scientific justification for the measure, and then if science wasn't sufficient, to note that. But the idea wasn't, the questioned about, how yeah, I think the WTO appellate body became such where you didn't have to have all science, you just had to have some science supporting what you wanted to attain through your legitimate state objective. And this source of arbitrariness obviously becoming more scient around the world as not only the United States, but other countries raise national security, stating that consequently it's self-judging, it's not justiciable, leading to this Smithian world where he who declares the exception rules absolutely. And this is particularly a problem with the most powerful countries in the world doing this. And there's indirect effects of this. What it does is, and I'm working on another book on China and the international legal order. You just see the empowerment of national security bureaucracies, and the mindset of national security bureaucracies is much less sensitive to legal matters than the Ministry of Commerce and other ministries. Which traditionally, both are concerned about other partners, trading partners, adherence to law, and consequently their own adherence to it. So it just shifts, who has power over trade policy. And we see this in Washington, D.C. as well. And then finally, if you think about proportionality, the whole WTO system was based on proportionate responses, so that if you found a violation, the dispute settlement body would authorize retaliation in a proportionate amount that would equal to the amount of trade that was nullified and impaired. If you think about the anti-dumping and subsidies agreement, they're also about proportionate responses to the amount of the subsidy or the amount of the dumping, and to offset them. And now suddenly, though, what we're seeing a world where tariffs can be threatened or changed overnight from 25 to 50% at the leader's whim. Just think about with Vietnam, what's happened recently, so that, there's a quote, new deal with Vietnam, a handshake type of deal. But the idea, what's declared is that Vietnam's going to have 0% tariffs. Vietnam being a lower middle income country on goods from the United States, but agrees that it'll be subject to a deal of 20% tariffs within the United States. So this is the world of IEL that we now face, with negative implications that extend beyond IEL. So I want to turn next in the next part to talk about how do we think about the rule of law transnationally, because if you don't think about international law and IEL, it's not just about compliance, because again, though any law should be subject to normative critique. It's about these basic rule of law values. So let me just start off with a quote. And this is a quote from Ernst Fraenkel. Ernst Fraenkel wrote a book called The Dual State regarding law in Nazi Germany, which clearly violated, basic rule of law notions. But what's remarkable is this passage that he has, which he says that the legal theory of post-war German counter-revolutionists, the Nazis, was decisively influenced by international events and the concept which permitted an unlimited sovereignty to ignore international law is the source of the theory that political activity is not subject to legal regulation. This was the presupposition, he writes, of the prerogative state. The prerogative state meaning it's up to the prerogative of the Führer, of the leader, to determine when law will be applied and how. I find it quite remarkable because the book is about national law, but he notes the link between evading international law in order to evade its constraints on powers exercised, and it's linked to what's happening nationally. And I think we're seeing this in countries around the world. So it captures my core argument that the rule of law is likely to progress or recede in parallel at the national and international level in virtuous or vicious cycles. And we're now in a vicious one. From this perspective, international law and IEL are critical for law from a rule of law perspective in the ways that they intermesh with domestic contexts. So I'm going to talk about three ways that the international economic law can matter for the rule of law. First of all, in terms of peace. Second, in terms of its indirect effects. And third, in terms of providing direct access to complaints. So the first was with respect to international peace and security. If you think about so much of the international economic law regime was about peace and security after World War II. It's about creating institutions to resolve disputes. It's about creating financial stability and international economic law stability generally. And the idea is that this would lead to more stable societies, and that financial stability and peace are interlinked because peace leads to stability within countries, but also financial stability is more likely to lead to a stable, thriving domestic systems so that you don't have radical parties which come into power and undermine the rule of law. And just to quote Keynes, who was central to the Bretton Woods system, and actually in the very preamble to the GATT, the concepts of full employment and a stable social order come out of Keynes's general theory. Keynes, set out to save what he called capitalist individualism from the scourge of mass unemployment, which he saw, if left unchecked, would make authoritarian state systems the norm in the Western world. And so you see this, you think also about regional integration in Europe, how central it was to tie Germany and France together in an attempt to create through economic integration a way to create peace in the European continent. And Jean Monnet, who was so central to that, was quite fascinating because I've been doing a lot of reading on the interwar period right now in the League of Nations. He came out of the Economic Bureau of the League of Nations. So second, if we just think about indirectly, so how international economic law can support the rule of law domestically, think about GATT Article 10 and its requirement of transparency and due process and the review of regulations, trade regulations. Think about some of the WTO jurisprudence. And man, I mentioned the Section 301 case where the panel stressed the importance of the indirect effect of providing individual traders with certainty and predictability from the arbitrary action of governments. Think of the famous shrimp turtle case brought jointly by India, Malaysia, Pakistan, and Thailand against the United States. Here, although the appellate body found that an important goal and ultimately that the United States could require the protection use of sea turtle protection devices for the import of shrimp into the United States, it found initially the United States was in violation of, was acting arbitrarily. It was arbitrary in that the certification process was not transparent or predictable, did not provide any formal opportunity for an applicant country to be heard or respond to any arguments that may be made against it, did not result in a formal written reasoned decision, and provided no procedure for review. All or to the different sources of arbitrariness that we just addressed above. And what it didn't note was sort of the impact of a sudden U.S. ban on shrimp on poor farmers, shrimp farmers in Thailand. Thailand at the time was exporting about $1 billion of shrimp a year to the United States. The sudden ban created a glut on the Thai market. It led to a collapse in prices, the loss of investments by Thai farmers, and there was allegedly a number who committed suicide after losing their investments. And so if you just think about how an action, a measure without any due process can have major implications, major effects on the most vulnerable, you can see how important the indirect effects can be. Now, that's not to say that the indirect effects are automatic. Empirical work shows that there are limits to the ability of international economic law to support the rule of law domestically. But that's also not to say that it cannot be a supporting factor, as empirical work also shows. there were major impacts in terms of the transparency of government regulations around the world in the trade realm following the creation of the WTO. And third, international law can provide direct legal protections, legal accountability for individuals in support of the rule of law. The human rights courts in every region around the world, except Asia, are a great example of this. And of course, in international economic law outside of the EU, it's only really investment law that provides for this. And investment law itself, as we'll see, is subject to rule of law critiques. But as I wrote earlier in a piece in the American Journal of International Law with Sergio Puig, we argue that the rule of law should be central to investment law, whether it means reform of ISDS, investor-state dispute settlement, or the abandonment of it for some other institutional alternative. The core should be the rule of law, constraints on the arbitrary exercise of power, which applies to all individuals, of course. Some involving we'll get to balance in a moment. So does that mean then that international law, economic law is an answer to the contemporary challenges? Well, of course not. The answer, as I say, it's not that it depends on if one focuses on legal compliance or international economic law, rule of law in terms of certain ideals. And once one turns about it in certain ideals, then international economic law and international economic law institutions also are not only can be supporters of the rule of law, but they also need to be subjects of the rule of law. They also must be assessed and critiqued from the rule of law perspectives. And this is one of the, the key points of the challenges with respect to international investment law today. So I'm going to go a little bit more quickly, just in order to lead time for some questions. But I just wanted to make 4 points with respect to what might be done, in my view. And so, first of all, I think it's very important to see the tensions within liberalism itself, and that is between political liberalism and economic liberalism. And Danny Roderick has been pointing this out with respect to tensions between democracy and domestic governance and neoliberalism or trade, the removal of trade barriers. And I've done this in my work about just refocusing on the importance of social inclusion and economic development in order to save globalization from itself. Because if it goes too far, we're going to see sort of the rise of inequality. We're seeing the rise of inequality to levels that didn't exist since the interwar period. And we know how the social collapse and the polarization that led to and what the results were. And we're seeing that play out, in my view, today. Now, that doesn't mean a return to sovereignty-based norms as advocated by economic nationalists. We still need transnational processes to avoid trade and currency wars, to respond to financial crises, to combat tax evasion and avoidance, and to address other global and transnational issues, such as climate change, that implicate international economic law. Of course, there's more than just the economic issues, and we're seeing a cultural backlash. And I just because of time, I won't say more about that, except to say that the policy implications are challenging, but to start, policies addressing economic inequality and social precarity can help stem such cultural backlashes. And third, I just want to respond to the temptation that we see, particularly in the United States, calling for new trade alliances amongst democracies and to create trading blocs, in particular to isolate China. And I think that even though it's admirable to defend democracy, that the idea that we're going to move into a world of trading blocs is a major challenge. It empowers authoritarians around the world. It creates rival trading blocs, and it undermines sort of the underlying Hobbesian task of securing order, trust, and the conditions of cooperation in the world that we need for so many issues, in particular climate change today. And then finally, if you think about the it brings me to this sort of concern about turning inwards. Here I want to quote the philosopher Kwame Anthea Appiah, who writes, as populist demagogues around the world exploit the churn of economic discontent, the danger is that the politics of engagement could give way to the politics of withdrawal. Forgetting that we are all citizens of the world, a small, warming, intensely vulnerable world would be a reckless relaxation of vigilance. Elsewhere, he writes, has never been more important. Today, the terms globalist and transnationalist are wielded as epithets, at times with good reasons, but ultimately, we are all in this together. Thank you very much.
Thank you very much, Greg, for that masterful and very efficient coverage of the topic on the rule of law in the international economic law context. It's given us a lot of food for thought. And thank you very much for staying on for a little bit of Q&A. I'm sure the audience has questions that they might want to address to you. If you have a question, could you please raise your hand and to switch on your microphone, identify yourself, and put your question forward to Greg. Does anyone want to start off with a question? We have barely 10 minutes until the roundtable begins next, so please do make use of this time. We have a little bit of a shy crowd. May I take the prerogative, use the prerogative as the sort of moderator and ask you a real quick question to pick up on what you said, Greg. Firstly, you mentioned the big elephant in the room, which is not so much a hidden item anymore, national security, in which countries and states do have legitimate concerns about transparency of their considerations in national security measures. So how do you foresee that this could be dealt with in the context of rule of law, transparency, and explainability, if you like that word, of your measures or your actions?
Yes. Well, I think two things. One needs domestic checks, and one also needs international checks. And I think domestically, at least in our country, this can't be one person who makes these decisions. There's got to be, we actually under our Constitution and under statutes, Congress has a role to play. It's been abdicating that role, and of course, there's now litigation in the U.S. courts, and in fact, the Court of International Trade has ruled that it's an unconstitutional exercise of power under IEPA that the president's currently using to raise tariffs. Changing tariff rates every time that he seems to speak. But also internationally, I'm of the view that obviously national security is very important. I think the core, is with respect right now for the United States, with respect to its concern, is no longer with respect to the rise of China. And I have an article on this as well in terms of how to balance these sort of concerns. But I think that it is important for a country to have to explain itself. I think it is important to have criteria against which that it can be deferential judicial review, but it has to try to meet those criteria. Obviously, Article 21 was drafted of the GATT a very long time ago, so I do think it should be updated with respect to the current issues of the day, cybersecurity, and so forth. But I think there needs to be some sort of judicial review, and I ultimately do think that if there has to be a possibility for rebalancing, so that if indeed a country raises tariffs on national security grounds, and it claims that it's simply going to do so regardless of any sort of outside independent review, then other countries should be able to raise a proportionate amount of tariffs to rebalance the situation. I mean, that's the whole center of the GATT. It's not about the whole vision was about freer trade, not about totally free trade, and to create a balance. And that's a negotiated balance. And that's, if countries feel that there's greater national security risk today, then they should be able to raise tariffs. But the other countries should be able then to retain that overall balance.
Thank you, Greg. Can I just check? Maybe in white, lady, please identify yourself. Thank you.
Sure, thank you. Dina Javala from UNSW. Thank you, Professor Shaffer. So my question was, you raised the point of STS and, the need of justification and use of scientific evidence, right? But there was always an issue there, which is this use of science and justification was always only required if you needed to regulate, if you wanted to regulate, not if you wanted to deregulate, right? So my question in essence would be, in which case you actually didn't need to justify anything, or you didn't need to rely on science? And my question is, in a sense, if we read this in this way, if there is more of a continuity between some of the arbitrariness we see today and perhaps some of the instruments of international economic law that ruled the past 30 years. Thank you.
Yes. I mean, it's a great question, and obviously there was a huge amount of literature on the SPS agreement, and I've written about it as well back in the day when it was actually functioning. My own view is that we have to, one of the core functions, right, of having international institutions is the fact that countries, every measure that a country adopts is going to have external effects on others. And that's just the nature of it. There's externalities everywhere. And so you need to create an institution where, one, you can create a mechanism where you can deliberate, you can discuss those. And I think one of the beauties of the WTO system is the committee system. And that the whole idea of the committee system is that you need to meet and you justify, you explain, and you actually bring people together who would have us, as people who know something about, the risks, because we all want to address risks, and then they can challenge that it's not a risk or it is a risk, and you have some sort of discussion. Ultimately, it's up to the state, the sovereign state, to decide what risks it's going to take on. And I do think it's very important, and I think it was recognized that you get to define the level of risk that you want. And so that's a very deferential standard. But what I'm focusing on, just from a basic rule of law perspective, is the importance of giving reasons and creating a situation in which we give reasons, they're contested, we respond to those. And that's in a situation, in a world, I just think that's a much better outcome than one where especially powerful countries can just make decisions by fiat.
Thank you. I'm looking at Alex. Do we have time for one more question? One more question. We have a round table. Peter, please. Use the microphone in front.
If there's only going to be one question, I'm happy to give it away. Any other arm that was raised? No. Okay. Greg, thanks for a very inspiring lecture. I have a very short question for you. In light of the arbitrariness of the current US trade policy, and I think arbitrariness is a polite word in this context, in light of the complete rejection of the rule of law by the United States, is there really still room for negotiations? Or should at least these trading powers that have the economic ability to do so, should they confront the United States rather than try to negotiate? Thank you.
Okay. It's nice to hear you, Peter. I only heard the question was going to be from Peter, but I, of course, recognize your voice immediately. So my own view is that you see this both playing out domestically and internationally. It's a question of collective action problems. What the administration is so clever in doing is trying to put different parties in competition with each other. So if you think about the US, the administration's attack on law firms, it attacks individual law firms. And then other law firms sort of consider, well, if we make a deal, then, we'll get a special favor vis-a-vis the administration in relationship to our competitors or rivals. If you think of different universities are doing the same thing, they don't go after all universities equally at once. If they did so, universities would all work together at once, but rather they go after individual universities. And the same, of course, is with respect to countries, and that they don't just say, oh, it's going to be the same tariff with respect to everybody. If they did that, then it'd be very easy for different countries just to work together. But rather what it does is it toys that you're going to get a special deal. So Mexico or Canada will get a lower tariff than their rivals. And so they think, okay, well then it's better for us to get a deal because a 10% tariff is better than a 30% tariff or 20%, and we'll have a competitive advantage. And so the real challenge for the other countries around the world is that can they overcome this collective action problem? It's going to take leadership, and it's going to take countries working together. Of course, what the Trump administration has also said is that if you attempt to do so, then we're going to double tariffs against you. Which, of course, again, is simply arbitrary. It has nothing to do with proportionality, or it's just simply the use of coercive leverage. But I think this is the challenge that we're seeing playing out today, is whether or not countries can work together collectively as opposed to being played against each other.
Thank you very much. I saw that there was one last hand up. I'm looking at Alex as he's saying, okay, and that's the last question. If you're okay with that, Greg, please go ahead.
Yes.
Could you please identify yourself, speak into the microphone?
Hello, my name is Katerina Holzer, formerly with the World Trade Institute, now with the University of Eastern Finland. Greg, I would like to thank you for your brilliant lecture, speech as always, and I fully share with you the definition of the rule of law. And my question is very short, but still I would like to ask it. How do you see the near and midterm future for the rule of law, both in the area of in international economic law and also in the area of international law in general?
Great. Thank you, Katerina. It's good to hear from you. So, I didn't have time, but I actually thinking of ending this article with lines from a very famous poem from W.H. Auden, who wrote in 1940, right after Germany invaded Poland, and is called "If I Could Tell You." And the last lines of the poem, it's a villanelle, are, time will say nothing, but I told you so. If I could tell you, I would let you know. So that's the easy answer. I mean, on the one hand, I'm a pessimist, and I'm a pessimist. I think, the whole argument of the book is that we're now in a vicious cycle, that we see these challenges happening at the international and domestic level at once. But I think there are two silver linings that we need to keep in mind. The first is that we're not in the interwar period. We have major institutions that were created after World War II and the Cold War, both internationally and domestically, in terms of courts, in terms of other independent institutions, in terms of norms. And so they have some stickiness. And so we're not in the same situation, even though there's many, many parallels. And so I think that should give us some hope. And the second, I just think it's very important for us to remember, is that the rule of law is always going to be under pressure. And it's always going to be under pressure because power is at stake. And those in power never think that their power should be constrained. And so it's an immemorial struggle. We face a more difficult struggle right now, but it really depends on us. It depends on our engagement, just as it depended on those who came before us. and thus as it will depend on those who succeed us. Thanks.
Thank you very much, and thank you for the short delay for the round table that's coming up next. I apologize to you guys. Thank you very much, Greg. We really appreciate the fact that you took time to address the SEAL conference this morning or this evening. And I would like to, I have permission to say the next thing, by the way. Happy birthday, Greg. So, on that more optimistic note, thank you and happy birthday. Enjoy the rest of your evening, and we really appreciate your time. Thank you so much.
Yeah, thank you.
Thank you again, and happy birthday to Professor Shaffer for such an enlightening lecture. Next up, we will begin the first roundtable discussion, Trade in Semiconductors. Let us welcome the moderator, Dr. Pijan Wu, and the speakers, Professor Isabel Van Dam, Mr. Nicholas Liao, and Professor Mari Shimizu. Thank you.